Hello, my name is Anthony Zaller, and in this video I want to talk about mediation, the use of mediation in litigation, and what the parties should expect going into the process. So parties in litigation should understand about the process of mediation and what mediation means. A lot of times people get it confused with arbitration. They're two separate concepts. Mediation is a voluntary procedure that's non-binding on the two parties participating in the mediation. Arbitration, on the other hand, is a binding, basically a private judge or jury is hired to decide the case, and it's binding on the parties. Mediation is totally voluntary, and if there's no agreement reached voluntarily between the two parties, nothing's binding from the mediation process. So mediation usually takes place with a private mediator and not the court. Sometimes the parties can go and have the judge hearing the case operate as a mediator, but normally a retired judge or an attorney that knows that area of the law is hired and paid for a day or maybe 2 days to act as an intermediary between the parties to see if they can get the two parties to meet and resolve the case. Now, it's important that the mediator is not a judge, is not there to decide issues, but there to get the parties to move and see if there's a resolution that can be reached between the parties. So if the mediator is doing their job, his or her job well, both parties probably don't like the mediator. What they're doing is beating up on each side and telling them the weaknesses of their case to get them to move, and hopefully he can or she can get them to a middle point where they can agree to settle the case. Now, it's important to remember that negotiations and things said during the mediation are privileged and that they are confidential to a certain extent. Parties can't use admissions made during the mediation process against the other party. For example, a party can't go into court and say, you admitted during the mediation that you were negligent when you crashed your car or something like that. But it's important, though, for parties to follow their lawyer's advice in this regard, because if they do make certain admissions during the mediation process, it's like ringing a bell. You can't unring the bell, and the other side's going to know about that fact. And if they know about that fact and the case doesn't settle at the mediation, they can do discovery to get that fact out in litigation through other means. So it's also important to remember that the mediator's role in the process is not there to make friends, is not there to explain who's going to win or who's going to lose the case. It's there to get the case settled. So you need to understand that going in and understand what role they're trying to play and understand why they might be saying things to you during the process. The mediator, again, it's important to keep in mind that the mediator just wants to get both sides to move. So with that said, the mediator is probably not going to tell you about the strengths of your case, but is only going to be referring to the weaknesses of your case. This isn't a personal attack against you, it's just the mediator's way of getting the parties to move to hopefully a middle point to get the case settled. Now, even if the case does not settle at mediation, it could be useful, and it's still important for the parties to participate during that process. Oftentimes now, given this day and age and more complex cases, a case won't settle in one day. There's multiple days of mediation, and sometimes the mediator has to work the phones after a mediation as well. So given that mediation is voluntary, don't feel like you're pressured to settle the case if you're not comfortable in settling in the range that the mediator is proposing or that the other party is offering. It's a completely voluntary process, and you need to keep that in mind. So if the case does not settle that day at the mediation, that's okay. Nobody's going to take it personally. The mediator's not going to take it personally. The other side's probably not going to take it personally, and your lawyer's not going to take it personally. So just keep that in mind. It's a voluntary process. You don't have to settle the case in one day. And it's definitely a process. If it takes multiple days, or sometimes the parties can't reach an agreement and there is no agreement to be reached, but at least it's good to go through that process to see where they're at. And if it can't be settled, the parties know they have to litigate the case at that point. So I hope you found this video informative. As always, please subscribe to the channel and let me know if you have any questions. Thanks.